Good morning. I'm Ward 1 Councilmember Brianne Nadeau, the Chair of the Committee on Public Works and Operations. Today is Monday, June 29th, 2026, and I'm calling to order this public hearing of the Committee on Public Works and Operations on Bill 26-0670, the District of Columbia Government Private Data Privacy and Protection Act of 2026. The time is 10:02 a.m. I introduced Bill 26-67 with the support of Council members Lewis George, Henderson, and Parker as co-introducers. This bill establishes comprehensive privacy protections governing the collection, use, sale, and disclosure of individuals' personal data by district government agencies and third parties, as well as provides individuals with rights over their personal data. The bill also establishes a Chief Privacy Officer within the Office of the Chief Technology Officer to oversee compliance and implementation across agencies. Data privacy laws for government are essential to safeguard residents' personal information and prevent misuse by unauthorized actors. Public sector databases have increasingly become targets for cybercriminals who seek to exploit sensitive information for financial gain, identity theft, or unauthorized access to government systems. However, when handled responsibly and securely, data is a powerful tool for improving government services, serving as an aid to agencies in identifying disparities in service delivery, evaluating program effectiveness, and promoting community advocacy. I look forward to hearing from all our public and government witnesses today. In addition to being on Zoom, this hearing is being live broadcast at youtube.com/DC Council Public Works. All witnesses testifying on behalf of an organization will be given 5 minutes for testimony. All other witnesses will be given 3 minutes for testimony. If you are in the Zoom, I will call your name and we will give you an invitation to be promoted to the panel. If you're in person, when I call your name, you may just seat yourself at the witness table. So we're going to now turn to our only panel of public witnesses. Shauna Delavu, Joel Farquhar, Margaret Durkin with TechNet, and Zachary Taylor, Director of Government Relations, Consumer Data Industry Association. Okay, we can just go in the order that I read names. So when you're ready, you may begin. Oh, yeah. So, you are. Okay. So, well, then we'll give you, and
I know
we'll
it's
give you,
confusing. Sorry about
we'll
that.
give you 5 minutes then. No problem.
Thank you. Good.
Thank you.
Because that's what I prepared. I'd be in real trouble if not. Okay. Whenever you're ready. All right. Chairperson Nadeau, esteemed members of this committee, if any are listening, good morning. My name is Shauna Delavu, and I'm the founder of Bright Lines, a doxing prevention service headquartered in Washington, D.C. Many of our clients are D.C. residents. They're civil servants, activists, judges, community leaders, and some just people who have done nothing more than live and work here and found themselves as a result at risk. Councilmember Nadeau, to you and to your team, and I don't see Amanda, but to her as well, thank you for receiving my testimony last year. This legislation establishes much of what we hoped for, that you're leaving this council with this work in motion, with co-sponsors who I hope will carry it forward as a genuine act of stewardship, and I hope a lasting legacy. Thank you. Last February, I testified that DC's government databases were feeding data brokers, putting residents at physical risk. I pointed out OTR's tax system database with SCOTUS justices and Jan 6 trial judges searchable by name. I pointed to the DC BOE voter file linking names to addresses on voteref.com, and I showed you Scout and its lake of interconnected data sets. But that was before August 2025. Since then, we've seen over 11,000 neighbors detained illegally. Last month, the National Guard yanked a woman off of her front porch. Julian Bailey was killed by U.S. Marshals in February. As this so-called summer surge ramps up, we're seeing long arms and automatic weapons on our streets, high-speed chases ending in tragic deaths, U.S. Marshals tasing crowds of people willy-nilly. I worry not for our neighbors who may see prosecution in the coming months, but for those who sit on their grand juries, and here's why. Their faces will be known to the DOJ attorneys who prosecute criminal cases in our city. and as such, so will their identities. By selling data to data brokers and letting it be scraped from our online databases, our city agencies are actively facilitating this terrorism of our neighbors. Federal agencies have long been known to purchase data from data brokers to circumvent warrant requirements. I've provided lots of examples in my written testimony. Agents now access that data from mobile devices and from wearables to determine a person's identity in real time just by looking at them. Yeah, I don't have to explain to you, the risks to DC residents in this moment cannot be understated. This bill is worth passing, and it must be stronger for these reasons. First, the definition of personal data excludes publicly available information. I get the rationale, but the problem, of course, is that the OTR tax extracts, the voter reg data, the DOB building permit data, all of that's already publicly available. So arguably those data sets fall outside of this protection. Moreover, the bill doesn't touch what's already online. Like I said, the OTR data, the voter file that's on voteref.com. A chief privacy officer must be mandated, not merely permitted, to conduct a retroactive audit. To empower the CPO to effectively regulate the data held by Octo, they must have independent appointment. They must directly have counsel or executive reporting and the authority to issue enforceable directives. What this looks like in practice is removing the permission for agencies to determine themselves what data is core function. The bill must require each agency to enumerate specifically and publicly the data practices it claims as core functions, what data it collects, why, how it's published and shared, and with whom, and under what legal authority. The CPO must be able to direct and approve that. The definition of personal data also must be enumerated, and home addresses have to be front and center. On this, council can already act. DC Code 47823E states that OTR tax data may be published, not that it has to be. So we can act on that today to stop publishing it. Finally, I hold that residents must be able to enforce their own rights. The bill's enforcement provisions have to include fines, timelines, and accountability. We've seen this work when agencies face civil liability. Frankly, too, we need a companion bill that governs data brokers. I hope that under the steady hand of the continuing folks, if it's not Councilmember Lewis George as mayor, that we can become a model of privacy protection, not because it's legally required, but because we want it. And to the council, I'm asking you to be strong for us and to protect us, to make this bill as strong as it needs to be. And I tell you, you will save lives and you will make history. Thank you.
Thank you. Mr. Farquhar.
Hi, I'm Joel Farquhar. I'm a DC resident with a master's degree in computer engineering, and I work as a software engineer in cloud cybersecurity. I support this bill, and I just have a few recommendations which I believe would help strengthen the oversight and reduce ambiguity for district agencies and the entities covered by this. So my first recommendation is mandatory incident notification requirements. The current draft does not explicitly require any entities in the event of a data breach to notify OCTO or any of the data when any of the data covered by this act is leaked or hacked, etc. And so I suggest adding a provision requiring this notification and also to impose penalties if that is not followed. Unfortunately, there's a long history of entities sort of not reporting this and hoping to avoid reputational damage or showcasing embarrassment for screwing up. So I think having civil penalties in the event of that occurring would be helpful. My second recommendation is around security requirements. Right now, the bill says to establish, implement, and maintain reasonable administrative, technical, and physical data security practices. I suggest that we specify that falls under a framework such as NIST CSF2. So National Institute of Standards and Technology Cybersecurity Framework 2. And then my final recommendation is around compliance verification and record retention. So the current bill does say that entities are required to make available to the agency all information in its possession necessary to demonstrate compliance with the obligations under the Act, but it does not specify what information needs to be retained in order to make that sort of audit actually viable. And so I suggest that we add some language to the bill specifying what data should be retained and how long it should be required to be retained. And yeah, those are my comments. Thank you.
Thank you very much. Ms. Durkin?
Good morning, Chair Nadeau and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director for TechNet, a tech trade association. Thank you for allowing me the opportunity to speak today on the DC Government Data Privacy and Protection Act of 2026. Our members consistently place a high priority on consumer privacy, and the technology industry is committed to privacy and security in the absence of a federal privacy standard. We understand your concern and others' concerns regarding the misuse of personal data in ways that may expose individuals, including immigrant communities, to harm. And we share that concern and agree that certain categories of personal data merit heightened protections. Although this bill is largely focused on government data privacy, the bill also has implications for private third parties that contract with agencies in the district. We are concerned that this bill would create obstacles to effective and efficient government administration and could cause disruptions to government services. I've submitted written remarks outlining our suggested changes, and I'll speak today on some of those high-level concerns. Starting with definitions, the bill has a definition of personal data, and since the district currently does not have an omnibus privacy law, again, interoperability with other states is key in the absence of a federal standard. The term publicly available information in this definition remains undefined, and so we suggest that the council consider our neighbors in Virginia's definition from their privacy law for publicly available information. In the definition of sale, we request that the term quote or other is struck. This term as written could be interpreted broadly to include the services that third parties provide to DC agencies, and this could potentially make a third party's activities as a service provider a sale. And on the definition of third party, in our view, this definition combines California concepts of service provider, contractor, and third party into a single definition. And this could make it more difficult to delineate the types of service provider activities that would otherwise be permitted under other laws. We have a few red lines for sections 3, 4, and 5. So again, speaking high level, in section 3, we have some suggestions pertaining to consent requirements and third parties. We ask that you and the committee consider striking the retention schedules as well as the audit authority in section 3. And specifically in section 4, we have significant concerns about the district's opportunity to object. Granting the district veto power over subcontractors inserts government into routine business decisions, which would disrupt established vendor relationships and could potentially raise costs that are ultimately passed on to DC residents. Finally, it could create compliance uncertainty that would then discourage investment potentially and innovation in the district. We also have some concerns around Section 4D related to legal process, notifying affected individuals, and requirements around reasonable steps. Finally, in Section 5, there is a requirement that a third party has to provide to a covered list to the agency provides to a covered individual that the third party is listed. We believe that this would raise concerns and impact potential competition and confidentiality. Thank you again for allowing TechNet the opportunity to speak today on this bill, and I'm happy to take any questions.
Thank you. Mr. Taylor.
Good morning, Chair Nadeau, members of the committee. My name is Zachary Taylor. I'm the Director of the Government Relations with the Consumer Data Industry Association. I'm here today on behalf of our members, which are part of the consumer reporting industry that operates in all 50 states across the country. This includes the national credit bureaus, specialty credit bureaus, background check companies, and tenant screeners. As you can imagine, our industry works closely with personal data and is governed tightly at the federal level by a variety of federal privacy statutes, as well as the now more than 24 state privacy statutes that have been adopted across the country. Our priority with these types of proposals is to ensure, as we heard from TechNet, the interoperability, a level playing field so we can continue to provide our services which are net benefit to consumers, both in the district and in the surrounding communities. As noted, our concerns are very similar to TechNet's. We are concerned with the absence of a clear definition for publicly available information. Publicly available information feeds into the consumer reporting process. It is also data that we rely on to facilitate identity verification and fraud detection tools, which may help the district itself provide services to the committee's constituents. Similarly, in addition, we are also concerned by Section 4A5. This includes a restriction that personal data provided to a third party not be combined with personal data that third party obtains from other sources. As you can imagine, in the consumer reporting context, it may combine data governed by the Federal Fair Credit Reporting Act, the Graham-Leach-Bliley Act, the Driver's Privacy Protection Act, and public records obtained from the state. This is something that we cannot do. And we would like to work with the committee to clarify this. But short of that, I want to note, with so many states having acted already in the absence of a federal standard, and with the Council itself considering various piecemeal privacy proposals, including the health data privacy proposal put forth by your colleague, Chair Henderson, we do stress that it is important that the district consider a comprehensive data privacy proposal that aligns with those of other states first, but that consider the ways to ensure that policy here in the district aligns not only with the federal laws that govern our member companies and their data practices, but also the many other state laws that are already on the books. Certainly cognizant of some of the concerns raised here today. Consumer reporting is tightly regulated under the Federal Fair Credit Reporting Act that does have provisions that are quite explicit in terms of when and how we can share data for the purposes that can be shared that are limited in nature, and want to ensure that a final version of this does not conflict with the FCRA, includes important exemptions for the FCRA, for the GLBA, for Driver's Privacy Protection Act as well, and a clarification as to the scope of the public records that would be subject to this law, relying again on Virginia's definition, which is quite common across this country. With that, we respectfully request the opportunity to continue to work with you and those on the council moving forward on this particular issue as things evolve in the future. So thank you for your time today and appreciate your consideration. We did submit these comments for the record as well. Thank you.
Thank you very much. Thanks, everybody, for your very specific feedback on the legislation. Definitely makes it easier to work on it. Ms. Dillevout, you mentioned that some of the district's most sensitive data sets, including voter registration data, could fall outside the bill's protections because they're considered publicly available information. Based on your experience working with clients, are there certain district residents that face greater risks from this type of data exposure?
To apply to the address confidentiality program in the city, this is a special program that allows that your voter registration information, your home address linked to your name, are not published together over a period of time. You may not already have your name published with your address. One of our clients, this is also a program specific for folks who are survivors of intimate partner violence and domestic violence, stalking, and other folks who are being targeted. These are really vulnerable people. Our clients consistently are turned down from the program because they live in a house that has a public record attached to their name. When they moved in, someone applied for permits to move, right? The trees were cut down out front, and so Scout has their name listed next to whatever order was created to cut those trees or to trim those trees. Maybe they got solar panels, so Scout lists that. The actual inclusion already on voteref.com, which bought the voter file from DC for $2, is another reason that they are not allowed into the program. They're told they need to move. And I don't know too many folks who can afford to do that in this moment and buy a new house or find a new place to live at an interest rate that's no longer as low as it used to be. So it's folks who are already vulnerable who are most at risk. Arguably in like the nightmare scenario that I outlined that I think is coming, It is also folks of communities that are traditionally targeted, historically oppressed groups. So yeah, the most vulnerable citizens are the ones who are most likely to be targeted because of these programs.
Are there jurisdictions with strong data privacy protections for homeowner information that the districts should look to as a model?
You're asking me, Miss Ma'am?
Mhm.
Yeah. Oh, yeah. Oh, yes, ma'am. In California, and I know that it's a little bit difficult to compare a city state to a big state like that with a comprehensive privacy program.
Mhm.
But in California, there are civil liabilities if a county publishes an individual's name and their address on any online database if they are an elected official. Most counties, because they don't want to keep track of who's an elected official in what capacity, at like a local level, at a county level, at a state level, just refuse simply to publish names and addresses together. So now when you go to those databases to look up a California constituent, California resident, you'll find an address for an address. You search an address, you find an address. If you search a name, you may see a name, but no connected address or homeowner information. You can order a PDF, you can order the document in hard copy, and in neither case will it be present. Because they face civil liability. They will be fined if they share it.
Thank you for that.
Yeah.
Your testimony recommended allowing a private right of action for violations of data privacy laws. Are you aware of other jurisdictions that have adopted a similar approach and how it's worked in practice?
That's the only one that I have brought to bear, yeah.
Okay.
It's the California situation.
Great, thank you. Mr. Farquhar, your testimony recommends giving agencies 72 hours to alert Octo to data or security breaches. Is this timeline based on best practices or other jurisdictions?
I may have seen that in the NIST framework, but that was sort of just an arbitrary suggestion, with the idea being that you should notify as quickly as possible when the incident happens, not necessarily the details, all that sort of thing, but and then sort of have a longer period of time, say a month, to give a more detailed report on what happened. But I selected 72 fairly arbitrarily, just with the idea being that it would be sort of a heads up that an incident occurred.
Given that most district agencies are partnered with Octo directly as opposed to some of the independent agencies, is there any reason they shouldn't simply do it immediately? I mean, I would say maybe like within 24 hours, maybe less than that.
Yeah, I mean, personally, that would be my preference, to have a shorter timeline like that. I didn't want to sort of have companies or entities dealing with cybersecurity issues to feel like they have to put immediate response to that on hold in order to do this notification. But assuming the notification has loose requirements in terms of just saying that something happened without requiring lots of details, I don't see any reason why it couldn't be something like 24 hours rather than 72.
Okay. I do plan to follow up with the Office of the Attorney General during the government witness portion of the hearing about your recommendation of a $10,000 penalty for agencies. Can you explain how you arrived at this amount, and do you believe it's proportionate for agencies of different sizes?
Uh, no, I think realistically it would probably make sense to have some sort of threshold or thing to determine how big the entity is. Like for a tiny company, $10,000 could put them out of business, when for a big tech company that might be a rounding error. That was sort of just meant to be a placeholder suggestion that I believe there should be penalties, and then extra effort could go into determining what exactly the schedule should be. Just something to sort of incentivize companies to report this, rather than having them hold back the information, knowing that there will be no consequences to them failing to report.
Can you talk a bit more about your recommendation to align security controls with the NIST cybersecurity framework? How would it improve outcomes, especially in comparison to the language currently in the bill?
Yep. So, as someone who works in cybersecurity, I can tell you it changes very fast, and that's only more relevant with AI and all of that. The general idea behind this is that many smart people have spent a lot of time looking into this and creating sort of broad recommendations on how cybersecurity best practices should be implemented. And so the idea here was to sort of have a specific already existing framework that could be referenced and used rather than DC having to sort of reinvent the wheel. And then I think there's also benefits from compliance point of view where this framework is used by many other jurisdictions. And so for contractors, vendors, etc., who want to work with DC, it will help make their lives easier when there's sort of one standard that they are held to and can refer to rather than each jurisdiction they work in having different standards.
Thank you. Okay, Ms. Durkin, you recommended changing the definition of sale by striking the phrase "or other," but I think that would mean that if for some reason the district gave out data for non-monetary consideration, that is some kind of payment, some sort of payment in kind, those transactions would be exempt. Could you say more about what you're trying to accomplish with this recommended edit?
So it's my understanding from our members that we would want that struck just to make the definition as tight as possible and potentially not bring in more than the bill intended.
And did they have any examples of things they were worried that might be caught up in that?
I did not receive any specifics, but I can certainly reach out to them and get back to you in the committee.
That'd be really helpful. Thank you. Okay, you also recommended allowing third-party vendors to combine government-provided consumer data for internal use to improve their services and address fraud. That sounds okay on face value, but I think we'd want to know more about the internal controls that prevent inadvertent transfer or sale of commingled data. Could you work with the committee to help our team understand how this would play out in practice?
So I'm not privy to what our individual companies do in terms of individual fraud practices to prevent fraud, rather. But again, I could get back to you on that.
Yeah, that would be great. Thank you. Okay, and Mr. Taylor, can you please clarify, is your concern that the bill regulates data already covered by federal law or that it creates compliance requirements beyond what federal law requires?
Our concern with the proposal as currently drafted is that it does not fully and clearly align with federal law, particularly in relation to the combination of data received from a government agency and other personal data that we may receive from other places and purposes and furnishers. So the consumer reporting system, as you may be aware, combines information from a variety of sources governed by a variety of federal and sometimes state privacy statutes. So FCRA data is regulated by the FCRA, but the Gramm-Leach-Bliley Act is a federal financial data privacy statute. Our member companies don't meet the definition of financial institution under that statute. However, they are bound by the privacy requirements of it. Similarly, the DPPA governs the use of certain motor vehicle and driver information, requiring it be made available for certain purposes, including vehicle safety recall. That information may need to be combined with other information from other sources, such as pure public records provided by the district, to effectively identify the owner of a vehicle who may need service to ensure that their vehicle is safe to operate on district roads. Our concerns, to reiterate, is that as drafted right now, the inclusion of Section 4A5 does not contemplate, from our perspective, those circumstances where data is combined with other sources that is regulated. You can sort of picture the circumstance where a consumer's report has all that information from different purposes, but can only be shared under the permitted purposes enumerated in the FCRA. The FCRA, as you may know, does include preemptive provisions related to state efforts to regulate the system.
Okay. Got it. You noted that publicly available information is not yet defined in the bill. Could you give some examples of how other states have addressed this issue and explain why you recommend adopting a definition similar to Virginia's as opposed to other jurisdictions?
Of course, happy to. So generally, it is a standard definition incorporated in most comprehensive state-level privacy laws. We are looking for a definition that reads like Virginia's. It recognizes federal, state, and local records also makes reference to widely available media. I think in reference to the committee today and for this particular bill, it is the district's records that we purchase and access through publicly available means that would be of interest, and specifying that that is what is covered here is what we are interested in.
Did you say why Virginia?
Did I say why Virginia? Virginia is one of the first states to adopt a comprehensive data privacy statute. It is a neighboring jurisdiction to the district, and it mirrors the preferred structure we see across the country.
How many states have adopted since?
Overall, there are 25 states, I believe, as of today, that have enacted a comprehensive data privacy statute. Specifically, the number of structures that match Virginia's, I would have to get back to you on.
Sure.
As you can imagine, every state has slightly different drafting conventions, but the core function for us is an exemption from being considered personal data, information, and personal data contained in public records made available by federal, state, or local government agencies.
I gotcha. Yeah. I mean, I think I'd rather do maybe the most recent rather than the first, given that probably the states learn as we go. But I also am less concerned about geographic proximity since we're talking about digital records and vendors from all across the country. And Virginia, in my experience, has not always had the most consumer-friendly state legislature. So I think maybe that wouldn't be my model. But if you have others you want to recommend, I'm all ears. So.
Thank you. Certainly be back in touch.
Okay. Are there categories of public records you believe are particularly important for fraud prevention or identity verification purposes?
So we rely on a variety of records. Property records are number one. We combine that information with what's already in a consumer's report to accurately identify them. We also rely on accessing criminal records for the same purpose to match up people's information from other jurisdictions in a background check. Address information is one of those ways.
Okay, great. Thank you.
Thank you.
Thank you all for your testimony today. Appreciate it. We're going to turn now to our government witnesses. Okay. First, we're going to be joined by the Office of the Attorney General. So we're going to call up Kevin Vermillion, Director of the Office of Consumer Protection, Office of the Attorney General, and Lindsay Marks, Assistant Attorney General with the Office of Consumer Protection. And I'm going to swear you both in. If you could raise your right hand, do you swear or affirm under penalty of perjury that the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do.
I do. Very good. Thank you. When you're ready, you may begin.
Good morning, Chairperson Nadeau, council members, and residents of the district. Thank you for the opportunity to testify today on B26-0670, the District of Columbia Government Data Privacy and Protection Act of 2026. My name is Lindsay Marks, and I am an Assistant Attorney General in the Office of Consumer Protection at the Office of the Attorney General for the Districts of Columbia. OAG's Office of Consumer Protection enforces the district's consumer protection laws and works to ensure that consumers remain protected in the digital era. I handle a large part of our office's data privacy work and have gained familiarity with other jurisdictions' privacy laws and general best practices. I am also a certified information privacy professional under the International Association of Privacy Professionals. OAG strongly supports the goals of this bill and also proposed several recommendations to further balance individual data privacy protections with compliance obligations for district agencies. To receive basic services such as public assistance or healthcare from the district government, residents are required to share sensitive and personal information. Likewise, district employees must share sensitive and personal information as a condition of employment. But existing law fails to address modern data practices and the district agency's use of modern technology, leaving the public in the dark about how the government collects and uses their data. This is reflected in public opinion. Over 70% of US adults say they are concerned about how the government uses the data it collects about them. And nearly 80% of US adults say they have little to no understanding about what the government does with the data it collects. Trust is the fuel that sustains democracy, and in a digital society, trust depends on being transparent about how the government is collecting, using, and sharing personal and sensitive data, and ensuring that we are protecting the data we collect. This bill seeks to set clear standards for how the district government handles sensitive and personal data. OAG strongly supports the goals of the Government Data Privacy and Protection Act. First, this bill meaningfully strengthens individual privacy protections by limiting the district government's collection, processing, and transfer of personal data to what is necessary to provide a government service. This limitation is in line with residents' reasonable expectations of what the district government should do with their data. When a resident provides personal information to the district government to receive a government service, such as cash assistance or a driver's license, they should be able to trust the information they share will only be used to receive that service. Second, the bill requires agencies to be transparent and provide a clear and accessible privacy notice about how they are collecting and using residents' data. This transparency holds agencies accountable for their data practices and simultaneously fosters trust from the public. These guardrails are critical to ensure that information residents share for legitimate government purposes is not later repurposed for surveillance or other uses unrelated to why it was collected in the first place. We have several key recommendations that would bolster the administrability of the bill without sacrificing privacy protections. These changes would remove redundant requirements that would be onerous for the district agencies to comply with. For example, the bill requires a district agency to get consent from district residents before transferring their personal data to a third party. However, the bill already restricts an agency from transferring data except to carry out a government service. So this request for consent is unnecessary. And in practice, an agency would likely need to get consent from every resident it collects data about, because the definition of transfer is by necessity broad and would include providing access to data to a vendor or utilizing cloud storage, something agencies likely regularly do. As another example, the bill allows individuals to request that the district delete their personal and sensitive data. This is a common and important privacy right applied to private businesses, but it is impractical and less necessary as applied to the district government in this bill. This bill already greatly limits what data the district can collect and use, only data necessary to provide a government service. Given this limitation, it would be challenging to require district agencies to delete data upon request and still provide requested services to residents. Small changes like these would limit the burdens on agencies without sacrificing individual privacy protections. We also recommend clarifying some of the definitions in the bill and including the definitions of third party and transfer, and adding a definition for government purpose. First, we recommend clarifying that the definition of third party includes any entity outside the district government, to confirm the scope of the bill. Similarly, we recommend adding a definition for government purpose to clarify that it encompasses only district government functions. We also recommend clarifying whether the definition of transfer includes the sale of data. The bill currently limits the transfer of data except as necessary to provide government services, but it allows the sale of non-sensitive personal data with an individual's consent. As drafted, this distinction is unclear for agencies trying to implement the limitations and to individuals seeking to understand how their data is used. Finally, we recommend removing enforcement of this legislation from OAG, given this is not consistent with OAG's normal enforcement practices. OAG does not generally enforce laws against district agencies, and doing so would create a conflict, given that parts of OAG represent the district in litigation and provide legal advice to various agencies. We would also like to note that since OAG is not aware of all of the district's data practices, including all of the instances of data sharing and transferring, This is not a complete list of all of our recommendations that should be adopted. We are happy to continue to work with council to strike the appropriate balance between ensuring district agencies are able to fully carry out their missions and the data of district residents and employees is protected. Overall, we believe this bill is an important step in setting clear standards and protections for how the district handles personal and sensitive data. And we welcome the opportunity to work with the committee on our recommended changes, as well as any others that the district agencies might highlight. We welcome your questions.
Thank you so much. Appreciate your testimony. I think you answered some of my questions in testimony, but I am probably going to ask them anyway, because Amanda worded them in a very specific way that she wanted answers to, and she's not here to defend those today. So it's probably just for the good of the whole that we do it that way. I apologize for any repetition. Okay, so would a 72-hour notification requirement to OCTO after a security incident create any practical or legal challenges for agencies, particularly in situations where the scope of an incident is still being investigated, as far as you know?
So I think having an agency who experiences a data breach reach out as soon as possible to OCTO so that OCTO can work with the agency to mitigate the damage probably makes the most sense. I don't know entirely how agencies are set up or whether their IT professionals are capable of handling a data breach on their own. But I think as soon as immediately would be, and for 24 hours is a timeline, I think that makes sense. And as far as vendors, I think that that would also make sense. That would be a requirement that also makes sense to them.
And what do you think about the $10,000 per day civil penalty as an appropriate enforcement mechanism for agencies that fail to provide timely notification?
I'm not sure that that makes sense from the perspective of government enforcement. So,
Yeah.
for instance, when OAG levies a civil penalty against a private actor, that goes into our litigation support fund, and then some of it also can go into the general fund. But when if it's coming from another agency, that's just taking money from one agency, giving it to a different district agency, and then probably putting it back in the general fund.
Yeah.
So short of a private enforcement or enforcement against a vendor fining district OAG or any government enforcement agency fining other district agencies, I don't think practically makes sense.
Well, I'll give you another example. Is we're doing this with the language access law. But in that case, those penalties essentially are awarded as damages to the people who are supposed to be receiving those services, but not at each agency. Does that?
If there was a private right of action in the bill, that I think would make more sense. But as far as government enforcement against other government agencies, not sure that makes sense here.
Okay. See, now we're getting somewhere. Great. We heard a recommendation to allow third parties to commingle data for fraud prevention. How can the council ensure that an exemption along those lines isn't used to justify unrelated data collection or commercialization practices?
So I think that the testimony conflated the requirements in the bill. So the requirements in the bill apply to, I think, like third parties whom the district is sharing data with on behalf of, as vendors to support government services. My understanding of the testimony was that they're using publicly available data and commingling that with other data they receive, and that wouldn't be required. That wouldn't be required to meet the standards of the bill.
Thank you. Are you all aware of other jurisdictions that provide a private right of action under their privacy laws?
I'm only aware of a few jurisdictions that have set privacy laws for their governments. And I'm thinking of Utah and Maryland, and maybe a few states that have comprehensive privacy laws, certain parts of those laws might apply to the government, but as a whole, there aren't as many states that have such laws. And so I don't believe any of the comprehensive laws I've looked at had private right of actions as it applied to state.
Mm-hmm. Aside from a private right of action, what enforcement mechanisms would ensure agencies remain accountable and residents have meaningful remedies?
We do think that there should be an independent body that monitors agencies for compliance and can take action if agencies aren't complying. And Ms. Marks touched on this in her testimony. We don't think it should necessarily be OAG because most of our work is either defending district agencies or bringing actions against private parties, and it would be hard to combine those. But we do think that there are other independent agencies that may be better suited. And I'm not an expert on what the Office of the Inspector General does, but that type of framework where there is an independent agency that can monitor and oversee and investigate things that happen in other district agencies and take remedial actions and make recommendations. And so that would be our recommendation, is to find a framework like that.
Does OTR already have the authority to stop publishing bulk homeowner information, or do you consider the publication of bulk homeowner information a data privacy concern that should also be addressed?
I don't think we know that, but we are happy to get back to you on that.
How would you characterize the district's regulation of commercial data brokers? Does our privacy framework lack necessary protections related to this?
So I think this bill primarily addresses the district government's use of data, and it would not, for the most part, impact data brokers. I think, as some of the witnesses mentioned, we don't have a comprehensive data privacy bill that would address private entities.
Would you recommend adding provisions to this bill that regulate commercial data brokers?
We would certainly be happy to work with the council on such provisions, either in this bill or in another bill that applied to private entities.
Okay. Now, definitions, you talked about a bit in your testimony. The bill defines the terms personal data and sensitive data. Are you aware of any existing terms in district law that might overlap with these definitions?
There are a few bills, including the DC data breach notification bill and the DC vital records bill, that use the term personal information or personally identifiable information. Those are not exactly the same definitions, either with each other or with this bill, but I think that's okay given the different, that they apply to different scenarios.
Okay.
And I don't believe sensitive data is defined in DC law.
Do you recommend any modifications to either?
I think both definitions are a strong start. For sensitive data, I would consider adding precise geolocation, which is generally understood and included in many other definitions in other jurisdictions of sensitive data. And I would also consider defining publicly available data, which is used in the definition of personal information. That's generally a term that's understood to mean any data that the government releases. And so without like a strong framework for when the district government is legally allowed to make data publicly available, that's quite a broad exception.
Does OAG experience any recurring issues related to data privacy with federal partners or other jurisdictions or anything like that?
Not with federal partners or other jurisdictions that we're aware of. We're happy to check with other parts of OAG outside of the consumer protection area and get back to you on that. We do see recurring issues of with data privacy, but our focus is usually on private actors.
And what do you see with private actors?
We have many concerns. We see dozens of data breaches a year, if not hundreds of data breaches a year that we get notification of under the law. And then just generally concerning privacy practices that I think we've talked about with the council before, and about the need for a comprehensive data privacy law so that we can address some of those practices better.
How could the definition of third party be expanded to address existing data privacy challenges?
Our recommendation is that actually third party be modified to be clear that it applies just to the district government or to any entity outside the district government. I think we could get back to you on sort of how this would impact existing practices, since we're not fully aware of that.
Okay. Do you have any additional concerns or recommendations related to the definitions in the bill?
As I mentioned in my testimony, I think it's unclear whether the definition of transfer would include a sale of data, and that should be clarified. I also had noted that the term share is used throughout the bill, but it isn't a defined term. I think to the extent that it is different than transfer or not incorporated by transfer, that should be defined. And I think I already noted in my testimony as well that we believe there should be a definition for government purpose, so that the scope of what is permissible to, when it's permissible to collect and share or transfer data is clear.
Thank you. Are you aware of any limits or regulations on data collection by agencies under district law?
I found a few that I'm aware of. So the protection of students' digital privacy would apply to all schools and vendors of schools in the district. And then the Driver Privacy Protection Amendment Act covers the data collected about drivers by the Department of Motor Vehicles.
Are you aware of any circumstances that would permit a district agency to sell user data?
I believe that the Driver Privacy Protection Amendment Act allows district agencies to sell data to vendors who then provide data to authorized third parties.
Oh. Like LexisNexis.
I believe that, yeah, the Department of Motor Vehicles is allowed to sell to LexisNexis, who then is allowed to sell it to an authorized third party.
We see it in things like a private parking garage. You go in and out and they send you a notification that you didn't pay. They get that data to match your license plate that they took a picture of from data that comes from the DMV, so they know where to send the parking ticket to.
How are data transfer agreements currently structured? Are they contracts usually?
I don't think that's something we're fully aware of.
Yeah, I think that'd be a question more for like the operations folks. Although generally we do support that there be contracts in place that clearly spell this out.
Are agencies required to enter into contracts with third parties prior to transferring data?
I'm not aware of any such requirement. There might be something that Octo has internally, but I don't believe there's a statute that requires that.
Do you think it should be a requirement?
I think it may not make sense in all instances, such as like interjurisdictional sharing, but I think as a baseline and certainly for the most part, it would be best practice to require the documenting of the sharing and outlining how third parties can use the data.
Which agency is responsible for oversight of data sharing agreements and contracts?
I don't know that we sitting here know that answer, but Octo might be able to answer it for you.
The bill allows agencies to transfer personal data to third parties for, quote, government purposes. I think you mentioned earlier how you would want to define that, so I will not ask you again. Similarly, subsections 3C1 through 6 list several carve-outs from the bill's restrictions. Do you have any recommended changes or thoughts on the impact of this language?
Yeah, reading some of these exceptions and speaking to just a few of our colleagues, they're both simultaneously vague, which I guess doesn't fully give protection to agencies sharing in those circumstances, but they also could be read quite broadly. And so we would be happy to work with you on like clarifying and narrowing the language.
Okay. Are you aware of any limits or regulations on agencies transferring data to third parties?
Other than the two statutes that I previously cited, I'm not aware of any.
Okay. And are there any existing requirements for third parties regarding the nature and purpose of processing, type of data processed, duration of processing, and the rights and obligations of both parties?
I don't believe that's something we can answer. That might be contractually required by third parties, but I don't believe there's a statute that would cover that.
And how are third parties expected to handle data requests from other jurisdictions, such as Maryland, for example?
Currently or in the,
I think it would just depend on the particular contract that the data was collected under.
Okay.
But we aren't aware of any statutes, for instance, that govern that.
No regulations. Okay. Let's say the federal government requests district data from a third party under current practices. What would happen? And how does that compare to what's proposed in the bill?
I think that it just, again, would be a question of the contract between the agency and the vendor that had given that data to the vendor.
How often does the district receive data requests from federal, state, and local governments?
I don't think that we can answer that because we only have knowledge of what's going on at OAG. And even then, we're happy to follow up with our operations team that would be in receipt of those requests, but we certainly couldn't answer on behalf of other agencies.
Okay. Do you have any idea how often third parties request data on behalf of other governments or jurisdictions?
I don't think that we do outside of like FOIA requests.
And do you have any recommendations, any other recommendations for expanding or modifying the district's requirements of third parties?
I think as written, the requirements are quite solid. There's one notable exception was that as drafted, third parties don't need to notify the district prior to responding to a subpoena or a court order, and requiring them to provide notice prior to responding, I think would be an additional requirement that we should include.
And just this actually kind of goes to your last question, but clarifying the definition of governmental purpose to be really limited to the district government would be helpful, because then it doesn't include when another state government or federal government is using the data.
Okay. Thank you. Lines 176 through 188 of the bill allow individuals to request their data and related information from agencies. Do you have any recommended changes or suggestions for this provision?
I think I noted this in my testimony. Some of the sort of standard privacy rights when applied to businesses don't necessarily make sense when applied to government. And request to obtain information to the extent that that isn't already covered by FOIA may make sense in some instances. But given that the agency is already outlining on the privacy notice exactly what data they're collecting and for what purpose, I don't know that requiring them to respond to individual requests necessarily makes sense, although we may end up determining that it does once we fully understand all of the ways the agency is collecting and using data.
Do you anticipate any staffing, workload, or capacity challenges associated with fulfilling these data requests?
It's really hard to say. I do think at least if these requests remain, then an agency will need to have an individual similar to like a FOIA individual who is responding. Some of the requests are more onerous, I think, than others, such as the right to have information be deleted or to opt out of transferring of data, given that that data is the data the agency has would be limited to data that they need for services. Those types of requests from individuals would be probably quite onerous.
How feasible would it be to implement the proposed opt-out requirement?
I think it would be quite difficult for an agency to do. They would have to go through their records and understand what data they have that on that individual that isn't, they aren't required to keep under a certain law or required to keep to maintain the service to the individual. I think that would be difficult.
Are there any legal or practical barriers to allowing individuals to withdraw consent and require agencies to stop using their data within 45 days?
I'm not aware of any legal barrier necessarily, although an agency may be required to retain data about that individual under different retention policies. Practically, if the individual no longer wanted government services, then I guess it would make sense to allow them to have their data be deleted. Although a 45-day turnaround is quite quick for a government.
And one legal issue, and this is from our perspective and lens at the Office of the Attorney General, could be, for instance, obligations in litigation. If we are involved in a lawsuit, we have certain preservation requirements from the court and our discovery obligations that could get complicated, both with how long it's preserved, whether things are deleted, and like whether we're allowed to, this bill affects our transfer of that in discovery responses and things like that.
Understood. Thank you. Okay, so you just mentioned one circumstance in which data is required to be required by law to be retained, so that would be in litigation. Are there other instances? FOIA, I guess.
I'm sure that there are. I don't know that we have exact examples off the top of our head, just because these different agencies have different statutory requirements, both at the district level and federal level, and many different areas.
Other than statutory requirements, any other factors that determine how long a data is retained?
I think it just depends on the agency's individual data retention policies, and where the data is housed. For example, email retention policies could impact that.
And whose responsibility is it to ensure data isn't retained longer than it's supposed to be?
I'm not sure that we can answer that. It probably depends on an agency by agency basis, and Octo would probably be better positioned to let you know that.
Okay. The bill assigns enforcement authority to the Chief Procurement Officer and the Office of the Attorney General. Can you talk a bit about the responsibilities of the bill and how responsibilities the bill would place on OAG, and explain how, I'm sorry, it's Chief Privacy Officer, CPO is, the other CPO is also in our committee. Okay, and explain, we might have to fix that. And explain how they align or potentially conflict with OAG's existing duties.
Yeah, this is what I was getting at a little bit earlier in the testimony. OAG really doesn't enforce the law against other district agencies. Our role is either enforcing the law against private actors, which is what Ms. Marks and I do, and then other parts of OAG represent district agencies and defending them in litigation or providing them with legal advice. And so that generally, we recommend that this enforcement mechanism be housed somewhere else, such as the Office of Inspector General or a similar independent agency, given that it's not exactly the work that OAG does and can potentially present conflicts between our role as counsel to the agencies in a defensive posture and this being enforcement against those agencies.
Okay. Thank you.
Thank you.
That's all the questions we have for you today.
Thank you.
Thanks a lot. We'll now move on to the Office of the Chief Technology Officer, and we will be joined by Director Stephen Miller and Chief Data Officer Matthew Sokol. And I am going to swear you in when you are ready. Do you swear or affirm under penalty of perjury the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do.
Very good. You may begin your testimony.
Thank you. Good morning, Chairperson Nadeau and members of the Committee on Public Works and Operations. Thank you for the opportunity to testify today. My name is Stephen Miller, and I serve as the district's Chief Technology Officer. I'm joined by Matthew Sokol, the district's Chief Data Officer. I appreciate the chance to speak about the importance of balancing two essential responsibilities: protecting residents' data with the highest standard of privacy and ensuring the district's government can operate as a modern, efficient, and interconnected enterprise. At the heart of today's discussion is a simple truth. Privacy and performance are not competing goals. In fact, the strength of our privacy protections directly determines how effectively agencies can collaborate to serve residents. A secure and trustworthy data environment gives agencies the confidence to share what they must, protect what they should, and deliver the services residents expect. Across the country, we've seen state and local governments share this understanding. California, Seattle, Minneapolis, Boston, they've adopted public data and privacy principles that do exactly what we are discussing here. They protect sensitive information while enabling responsible data flow between departments. These jurisdictions show that you can establish strong privacy guardrails and still encourage agencies to work together seamlessly. Their models emphasize clarity, transparency, and public trust, values we share in the district. The district has demonstrated how well-designed data sharing improves real-world outcomes. The Deputy Mayor for Education in partnership with OCTO, the Office of the State Superintendent for Education, and the Department of Employment Services, and more, lead the Education Through Employment Pathways project that unifies data from K to 12, higher education, training, and employment systems to provide insight onto the effectiveness of our policies, and it drives decisions that support policymakers, researchers, and regional partners. This data and the valuable insight it provides improve outcomes for our students, our families, and our employers. This wasn't achieved by hoarding data. It came from breaking down silos in a thoughtful, privacy-aware way that allows responsible sharing and measures the outcomes that our residents expect from our education and workforce programs. We're seeing similar models in other states where data sharing between health systems, behavioral health providers, and housing authorities make it possible to support residents across multiple programs without forcing them to navigate the government on their own. Our peers across the country are using shared data platforms like data lakes and data exchanges to align decision-making across health, housing, and social service agencies. These collaborations are helping governments spot gaps, reduce duplication, and reach people who would otherwise fall through the cracks. One lesson is consistent across these examples. The cost of siloed data is borne by residents. When departments cannot safely and quickly exchange the information necessary to coordinate a response, whether it's for housing placement, benefits eligibility, education services, or public safety, the resident experiences the fissures in government. And too often, those fissures translate into delays, repeated paperwork, and inconsistent case information, or in the worst cases, preventable harm. The district has invested time and resources to build a data environment that protects people first and foremost, and also acknowledges the importance of data sharing to the functions of modern government. A resident doesn't interact with agency A and agency B. They interact with the district government. Their outcomes improve when our systems and teams behave as one coordinated organization. To achieve this balance, governance, not restriction, is the key. We must define how data can be shared rather than defaulting to whether it can be shared. Clear privacy standards, purpose-built limitations, role and data-specific access controls, rigorous audit logs, and consistent data inventories all give agencies the structure they need to collaborate confidently. When every agency operates under the same playbook, the friction drops and the trust increases. Cities and counties across the country have adopted frameworks and model data governance practices that reflect this idea. They emphasize data use rights, standardized sharing agreements, and strong legal and technical safeguards. But they also emphasize operational necessity. Agencies need to be able to share the right information with the right partners at the right time. The district must follow that same path, establishing a governance structure that protects privacy while enabling responsible, well-designed, well-tracked sharing. At the end of the day, this is about resident experience and resident outcomes. When agencies can collaborate effectively, we reduce administrative burden for families trying to access services. We improve program integrity by spotting anomalies and duplications earlier. We accelerate service delivery by removing redundant manual verifications. And we strengthen equity by ensuring that our most vulnerable residents aren't left to navigate the government alone. Chairperson and members of the committee, the district has a real opportunity here. By pairing strong, modern privacy protections with clear standards for interagency collaboration, we can build a government that is more trustworthy, more resilient, more efficient, and more responsive. We can protect residents' data with the seriousness it deserves, and at the same time, ensure that agencies can work together as one coordinated enterprise. Other cities and states have shown that this is not only possible, but achievable with the right design, the right governance, and the right leadership. Our residents expect their government to be both secure and seamless. With thoughtful action, we can meet that expectation and set a model for the nation. Thank you for the opportunity to testify. I look forward to your questions.
Thank you very much.
Thank you.
Okay. Same caveat as before. We're going to do our best to follow Amanda's wishes here with questions. Are any agencies currently required to submit incident reports to OCTO after security or data breaches?
There's a city administrator's order and a CTO's order that came out in August of 2022 that we request agencies give us 2 hours notice of security incidents and up to 24 hours for minor incidents. But we want to begin our investigation and support as soon as possible. We would ask 2 hours on that.
Wait. So is it 2 hours or is it 24?
It's 2 hours.
Okay, to you.
24 hours for non-security incidents, like we want to know about outages and stuff like that. But
Got it.
2 hours for something that would involve data or system access issues.
Got it. Thank you. And that's a mayor's order or city administrator's order, you said?
City administrator's order and a CTO's order.
All right. And those have been since 2022,
That's correct. August of 2022.
all under the same city administrator and chief
Correct.
technology officer?
Obviously a different chief technology officer, but the order still stands.
Yes.
It's an order coming from OCTO itself, and we found no reason to issue a new order. It's the same rule, the same leadership team outside of the different CTO, of course.
Does it expire at the end of the mayoral administration?
I'm not sure how it would work with a city administrator's order yet.
Okay. Requiring agencies to submit a more detailed incident report within 30 days after a breach be helpful to OCTO in improving cybersecurity?
I would say if we start that coordination within 2 hours or within that 24-hour scope, we are involved in that, writing that incident report.
Mm-hmm.
Yeah. Having a final report on a timeline like that would certainly be helpful. It would enforce cooperation through those 30 days.
Mm-hmm.
Yeah.
Can you talk a bit about the recommendation to align security controls with an established framework like the NIST cybersecurity framework? And are there risks that the framework could become outdated or create compliance challenges as standards evolve?
You know, it's not so much as standards evolve, but as technology evolves, that's where the risk comes in. But no, I mean, generally, we already link our security standards to national standards like NIST, SOC 2, all that great stuff. We aren't, we're not making anything up within OCTO. We're looking at what are our peers doing, what's going to make it easier for us to interoperate with the federal government for reporting requirements. That's going to come down to following standards like what you'll see in NIST.
Okay. How long are agencies currently required to retain access logs and security records?
Retention schedules are agency-specific, mission-specific. Within OCTO, we more or less retain for as long as possible. It really comes down to storage costs.
Uh-huh.
Yeah.
How long would be typical?
There is some data that we have going back 30 years. But there's, depending on when a service is created, if a service was created 2 years ago, we have 2 years of data associated with it. Yeah.
And do you think 2 years is an appropriate retention period?
I think an appropriate retention period is something that we should look into. It definitely, my interest is primarily how retention impacts our ability to operate and maintain the hardware and the infrastructure, the security apparatus. So the more data we have, the more security we have to have around it, the more storage that we're buying year over year, and the more operational capability we have to build out. It does create a longer retention period. It creates a greater burden for things like FOIA, a greater burden for, again, just day-to-day operations for us, making sure that we have hard drives, making sure that we have network capacity and everything built up.
And do you think mandatory retention creates any cybersecurity or privacy risks?
Having 30 years worth of data certainly creates a cybersecurity risk.
We heard a recommendation that OCTO should be authorized to conduct compliance audits. Do you agree?
Compliance audits, it would be something that we're capable of doing if we were to build out the capacity for it. We would have to make sure that it was scoped within the mission of our agency around cybersecurity, around good data governance.
Is it something you would like to be able to do?
It would certainly help with ensuring that we have a secure IT systems across the city. It would certainly help to ensure that we are reducing risk for our residents with the data that we retain.
Does Octo conduct audits of publicly available district data sets?
No, we do not conduct audits of publicly available outside of the scope of what DC government itself makes publicly available. So we would, for example, our open data portal, we have the capability of auditing, what's going on with that, but it's low risk data in those cases. Yeah, it's all level 0 data, what we would call the lowest risk data. Matt.
We provide guidance through the mayor's order 2017-115, which is the DC data policy to help agencies understand what they're putting out on open data DC. Ultimately, the general counsels of those agencies decide what can be made open and what cannot. That is not a direct function of what Octo does per that policy.
And what would the process of retroactively auditing district data sets entail, and how long would it take?
We'd obviously have to look at every single field in every single data set. There are about 1,500 available on Open Data DC today. And we would have to work obviously with each agency that is responsible for those data sets, or come up with a specific plan to work with those agency data officers and their general counsel to actually be able to enforce that mechanism.
How long do you think that would take?
I couldn't I'd have to really look into what the details of what that would be. I think it would be extensive. I don't want to give an exact timeline for that though.
What data sets would you prioritize for review?
There are data sets that do contain things like people have talked about, like the public extracts. Those are ones that we've heard about in the past. Those might be ones we want to prioritize as an example.
Can you describe the enterprise data set inventory and explain what types of information and data it captures?
Sure. The enterprise data set inventory is essentially what we do to acknowledge the existence of a data set. It does not actually provide any information regarding the specific records of a database. It's more, think about it as metadata. So we do provide several pieces of information of which agency is responsible for it. If there are, what is classification level per the DC data policy, if there are exemptions as to why it is classified at a certain level, we include that. We also include other information around specific sensitivity types, whether might be something like CGIS or FERPA or HIPAA or something like that. We also include some other relevant pieces of information. As an example, does the data set contain race or ethnicity data? Is it currently used as an AI within an AI tool? So it's expanded over the years, but it's really just metadata about those data sets. And there's about 2,600 data sets that are classified within the EDI.
Would you agree it's a significant source of resident exposure?
The catalog itself is just a catalog of catalogs.
Okay.
So yeah, there's no resident data itself in there. It would explain where resident data is within the agency, but the enterprise data inventory itself is very safe. It's a level 0 data set itself.
So it's more about the roadmap that it creates that we might be concerned about.
Yeah, that's correct. It's information that we can operate off of in the event of a data incident or a cybersecurity incident. It gives us information that we can then utilize in that investigation. It also helps us when, say, we're doing like project planning and stuff like that, so we can see what can be shared between agencies easily.
So specifically with the enterprise data set inventory, are there any changes you would recommend to limit resident exposure and better support district privacy goals?
I wouldn't necessarily say, again, as we're not actually exposing any record information itself. It's really just about the data set that we acknowledge its existence. Again, we're giving rationale per the DC data policy as to why we have classified a specific level, for example, level 3 or level 4 data, and there's a reason why it is not publicly available.
Got it. Does Octo have any safeguards in place like anti-scraping protections or limits on bulk downloads?
No. So we do make sure that we do want to make sure that people are responsibly utilizing dc.gov, right? It's very hard to actually enforce these things on the internet. The internet is the wild, wild west. We can say, we can put in our metadata, pretty please do not scrape this website. That does not prevent anyone from actually scraping it. Responsible bots won't scrape it. If you put that information up there, you could say no bots, but it really doesn't stop a bad actor from being a bad actor.
What types of protections do we use to prevent scraping as much as possible?
So we have protections on the network and within security infrastructure that can detect large movements of data across the network, large movements of data leaving the network, so we can monitor that. That also helps in investigations. We can see, not necessarily that gigabytes of data was leaving within 2 minutes, but that over a slow period of time, megabytes of data was slowly moved away. This is primarily used in investigative purposes. We don't know if in a given day, it could be that a responsible third party that is authorized to pull large amounts of data from the district, from the network. So we're not necessarily stopping things unless we're told to stop it, or if we see something like data is moving into Russia, data is moving into Iran, North Korea. We block these things, but just as an example, that's, we have security automation that would look at that.
So you can tell it's happening in real time?
Near real time, yes. But again, we're not aware if it's, unless we know it's going to a bad place, something that we have, we know IP addresses where we don't want things going. We know parts of the world where we don't want data going. We also know that certain data shouldn't leave the United States. So we would have, monitoring in place for that. But generally it's, we don't want to interrupt agency operations. So we work with agencies to allow them to move data as much as possible.
So if you see a large amount of data moving somewhere, but not Russia or China, what do you do?
We can notify an agency of it. Yeah.
So would that be a real time, like, I'm going to give you a call, or all this data is moving off your site, or is it something after the fact? How does it normally work?
It can, depending on what we're seeing move. If it's low, if it's, we're seeing a large amount of level 0 data moving, we're not going to bother anyone with that. But if we see a level 2, level 3, or level 4 data that we're aware of moving, yes, we would proactively work with an agency to identify that. Same thing, we would monitor email transmissions to look for large amounts of data that are going. We would stop someone inappropriately sending things like social security numbers. We have security architecture that would stop that already in place, stuff like that.
So you can stop data transfers if you see them happening and you're alerted to it being.
Yes. It depends on the data. So it is things like, we know that we can't be sharing social security data outside. So that's examples where we look for those patterns in, attachments or in the email message itself.
Emails, I think, presumably you have more control over, but when it comes to website data scraping, et cetera, do you have the ability to stop that in progress?
We can stop it in the systems that we control. Yeah. So email is a great example because it is a system that we 100% control.
Right.
When you look at things like an agency website, an agency theoretically can build a website without us. They can put it up as a .com, which means we're not aware that it exists and it's not within our security oversight.
Okay.
Yeah.
But for the sites that are on dc.gov, you have the ability to stop data transfers.
We'd have the ability to stop that. If an agency is on, we'll say, our public websites, we're going to stop them from putting sensitive data up to begin with.
Yeah.
When it gets into the application scopes, that can get a little interesting. We may not necessarily be able to see the data as it moves out because of how applications are, built with, you're getting into it based upon who you are. So I talked about in my testimony about making sure that we have user-based or very data-specific access control. If an account for Stephen Miller is seen moving large amounts of data, well, Stephen Miller is authorized to move that large amount of data. We're not going to stop Stephen Miller from moving that data. We may not know that Stephen Miller is an account that's currently breached, for example, in that application. Not necessarily on the enterprise, we would definitely know that Stephen Miller was breached, but within an application that's not within our direct control or operations, we may not be able to see it.
Okay.
Yeah.
Are there any safeguards for any anti-scraping protections that exist that we don't currently utilize that we could?
So again, the internet's the wild, wild west. There is definitely not much that we can do about this. We can work to block these tools, but a tool can be, we can work to block a tool, for example, again, operating out of Russia, operating out of North Korea, operating out of Iran. But a bad actor operating out of those countries can have a VPN into Oklahoma. They can have a VPN into Richmond, Virginia. So yeah, we don't necessarily see these.
But any software and other products out there that we're not utilizing that other places are that we should be?
I don't want to say that this software gives you 100% coverage. I think I'm trying to hedge around that. It's not, a bad actor just doesn't follow the rules of the internet. And these data scraping tools are set up to follow the rules of the internet. So you have meta tags on your websites that say, don't scan this, no bots. And yeah, bad actor doesn't care about the instructions you put in there.
Okay.
AI tools, they care about it now. Yeah.
Got it.
Mm-hmm.
The bill defines the term covered individual as someone who works or lives in the district or receives district services provided by an agency regardless of their permanent residence. Do you have any thoughts on the proposed definition?
I don't know. We do want to make sure covered individual can cover anyone that interacts with the district government. We have millions of visitors here. We have people that come in from Virginia, Maryland, Delaware, West Virginia, Pennsylvania every day to work. We want to make sure the covered individuals is as broadly defined as possible. They may not be getting every government service, but they can report a pothole, and we're going to ask them what their name and email address are to report that pothole. They can call 911. We're going to ask them what their name and address is when they call 911.
Okay. And the bill also defines personal data and sensitive data. Are you aware of any existing terms in district law that might overlap with these definitions?
I evaluated district law. I didn't find anything that overlaps with those definitions. I think you've provided some pretty comprehensive definitions, and what exists doesn't conflict with it. I think you're creating a new standard.
Okay. And you don't have concerns about it?
I don't have concerns about it. No, not with those two definitions, no.
Okay. Do you have any recommendations on how the definition of third party could be expanded to address existing data privacy challenges?
I think we have to make sure the third party is defined responsibly. That's, I think that's an important aspect of this. Our assessment finds that you defined it adequately broad, but we definitely want to make sure that there's an understanding that there's exceptions for DC government's own workforce. Again, I want to make sure the DC government can interoperate as much as possible. Third party, again, is usually going to mean a non-governmental entity. Usually it's going to mean an external entity. Usually it's going to mean a person that is receiving, collecting, storing, processing our data. We just want to make sure that we're not limiting how we can operate in the government and the trusted partners that we work with to make that happen. I guess some examples of that, just so you think about this, it is we do operate a data center ourselves. That data center is not owned by the district. We are leasing space in that data center. Are they a third party? Email is provided by Microsoft. Are they, how is that defined as a third party there? And how are we going to make sure that we're not limiting the ability to deliver our email? Those security appliances that protect our email every day, again, that's a third party.
Mm-hmm.
Yeah.
And do you have any other recommendations related to definitions in the bill?
No, generally, again, we just want to make sure that the definitions in the bill, they don't conflict with modernization initiatives, modernization projects, that we want to make sure that we can continue to simplify how someone does business with the government.
Okay. What categories of data are agencies allowed to collect?
That's going to be very agency mission specific, and it probably even gets down to the programmatic level, right? So they'll have, that will be defined by, their programmatic needs to meet that mission. And then, they're going to try to minimize restrictions on data collection. A lot of it comes down to the practices of making something simpler, try to ask fewer questions, try to ask only what's legally necessary. But no, we're not aware of any comprehensive limits on what data can be collected by agencies outside of federal laws.
Do you work with them when they're creating forms and things like that?
We do. We do try to work with them. We try to simplify them. I think examples of this, as we work through things like a single sign-on project, we want to make sure they're not collecting information that we already know about a person. If we know their name is Stephen Miller, we shouldn't ask them, what's your first and last name? We already know it. That's just an example. But as we create, secure profiles for individuals, we have to make sure that we're not collecting that information again. And in a truly interoperable government, if we collected 30 pieces of information from you for government service A, it would be great if we could share those 30 pieces of information for government service B in a different agency. We work on that. We're working on the principles around that. We want to make sure this law does not get in the way of that.
Okay. What data privacy policies and practices do district agencies currently follow?
So again, it's going to be mission specific, right? So our health and human services agencies, they're going to be following the federal laws around, health insurance portability and accountability. Our education agencies, they're going to be following the laws around the Family Educational Rights and Privacy Act. The DMV is going to be following the law around the Driver Privacy Protection Act. Our law enforcement and public safety agencies, they're going to be following what's appropriate if it's CJIS or something issued by the Bureau of Prisons, et cetera. There's also the industry standards and the Octo data policies that we ask them to follow as well. And then, of course, we try to set our standards and policies around guiding bodies like NIST for the most part.
The bill requires agency websites to link to a clear and accessible privacy notice created by the Chief Privacy Officer. Can you talk a bit about how this requirement would function in practice?
Yeah. If this bill were to go through and a chief privacy officer were reporting to me, I would ask them to create a central privacy notice. I would give them, a couple of months to get this done. It is kind of comprehensive. We'd want them to work with agencies. So we'd have, just for example, the assistant city administrator through the government operations group help us to coordinate with every agency to make sure they understand why we're doing this, what changes may occur, solicit feedback from them on what that privacy policy should look like. Then, once we get to a final document, we have a centralized place on dc.gov where privacy and security notice lives today. We would replace the privacy portion of that notice. So most existing sites would already be linking to the appropriate place. And that's for a general central privacy notice. It is relatively outside of building the notice itself, which I think would take a little bit of time. Getting it up in public is relatively easy on the Octo controlled infrastructure.
So no logistical concerns?
We don't believe so. Agencies have a lot of legacy systems, so we'd have to investigate what that would look like. Whether or not they have the access to add an updated privacy notice, we'd work that out. We would just ask them again to link into the centralized one if they had their own privacy notice up. That tends to be one of the biggest logistical concerns, tends to be static, stale content on legacy systems. Yeah.
Okay. All right. And do you have a rough idea of how long it would take to finalize the privacy notice and make it available online?
I do think like 90 days is a good timeline to put something like that together. It is really going to be dependent upon some of that agency feedback. So, we don't have a chief privacy officer today, so I don't have someone I could sit down and talk to about it. But, talking it through with my general counsel and talking it through with his team, We do think in practice 90 days is reasonable. It really is going to depend upon what we hear back from agencies on what would go in that centralized notice.
And do you think it's 90 days could be inclusive of the agencies adding links to their websites as well?
Yeah, we think so. We think it's kind of reasonable. Maybe an additional 30 days because of the legacy system issue as we work through that.
Okay. All right. And then the goal would be a single comprehensive set of rights and notices.
At this point in time, I believe yes, but we would, through that stakeholder engagement, we may get more information that says there's a responsibility under some agencies to that collect data that's very specific to them that wouldn't make sense in a centralized notice.
Okay. Would any agencies be exempt from including this information on their websites?
I don't think so. I think if it is the goal, if the goal is to have a privacy notice available to residents, every agency is collecting data in some form. So we would want to make sure that every agency, at least not necessarily at an application level, at an agency level, is thinking through how that data privacy notice aligns with their mission, aligns with their programmatic goals. But those different rules, different laws, different policies that aren't necessarily coming through Octo may impact that. And so I think it's possible. Do I think every agency? No, I think it's going to be some specific agencies.
And does Octo have the tools to effectively monitor and prevent the sale of data by agencies?
So at this time, that is not in our statute. It's not something that we have legal authority for to perform that function. We don't have necessarily the tools built to track it. I don't know if I were to buy something or if we would build something. So that would be my biggest concern with that. We lack the current legal authority and we lack the tooling at this time.
Okay. And does the bill give you what you need?
The bill gives us the authority to catalog and review and approve. We'd love to make sure that we can audit those third-party data transfers if the bill were to go through.
Okay, so we'd need to update that in the language?
Yeah.
Could you work with us on that?
We could work with you on that.
Okay. Are you aware of any circumstances where an agency would be required to sell data in order to provide a service or perform its core function?
I'm not aware, I'm not party to the agreements to it, I guess is a way to put it. So I'm aware that there are instances. I don't have all the details on it since we're not necessarily a party. Would be required is also an interesting part of that. There are instances where the data that's being shared technically can be shared as level 0 data through the open data portal. Yeah.
Can you give some examples?
Some examples where it kind of needs to be done. I mean, it's definitely, helping to reduce fraud with our, residents is pretty important.
Yeah, so again, we've got like DC Gov employees, they have benefits plans, so subscribing to those which require transfers of data. You have healthcare claims and clinical data to regional healthcare information exchanges that work with other states, jurisdictions. And you have some cloud-based systems around schools so they can manage student data such as grades and attendance and scheduling.
Okay, that makes sense. And let's see, are you aware of any limits or regulations on agencies transferring data to third parties?
So there's some that touch on it, sort of. So you've got things like you have procurement laws, you have FOIA, you have some records retention schedules that are laws. You have things like the mayor's data policy, DC data policy that provide some information around that. And then Octo provides IT security and network standards for those as well. And then agencies may have their own individual policies. around this. So the DC government agencies really remain subject to the overarching data policy requirements and have to follow their own internal policies, federal requirements, and then applicable confidentiality provisions.
Yeah, generally it's scattered across the agencies itself. So yeah, I'm aware that they exist, but we don't have them all cataloged.
Okay. And they are largely not in statute except for a couple of the examples we've heard referenced today.
That's my understanding. Yeah, some of them might be policies and some of them might be based upon orders from the mayor or from the city administrator.
Okay. And how are data transfers, how are data transfer agreements currently structured?
So currently, the data transfer agreements are, they specify certain pieces of information about it. So what information is going to be exchanged, what's the methodology that they're going to exchange it, and how often they're going to exchange it. And so if an agency is working with a third party that's a vendor, the data transfer agreement is usually worked out within the contract itself between the government and the vendor. If the data transfer is between two agencies, it's a data sharing agreement or an MOU. You know, and Okta is really only aware of the data transfer agreements that we particularly participate in, and that's usually through utilization of our services and platforms, our data integration stack, our data lake or data warehouse, for example. And obviously, anything that's level 0 open data is available without an agreement.
And do you have examples of data transfer agreements or contracts between agencies and third parties?
We have the agreements that we're party to, and we can work to provide the committee.
What would be an example of one like?
I think again, benefits services
Okay.
might be one where we're working with a healthcare provider or financial for 401k or something like that, where we're providing. Yeah, and another one such as ETEP, where we're working with other third party agencies to provide that student and workforce data.
Okay. How are third parties expected to handle data requests from federal, state, or other local governments?
So generally speaking, the third parties such as vendors have their own processes for handling data requests from federal, state, or local governments. We would expect a vendor who's working with district data to notify us as customers if they received one of those specific requests directly from an outside entity for the third party.
Okay. And do we currently have any set regulations or practices that the third party in that other jurisdiction would be required to follow?
Again, I think procurement law is an example of something that is a district regulation that third parties would need to follow. And obviously, there's various other federal privacy policies that govern the use of data from the district to third parties and other jurisdictions that would be required to be followed.
And how do these practices compare to what's proposed in the bill?
So, we don't, I'd say as Octo, like we operate systems really that's for tracking all of this information. We receive questions that we sort of administrate, right? So we only have authority over certain things such as emails. We have network logs, we have system logs, right? That can support things as legal holds, litigation requests, and FOIA.
And how often does the district receive data requests from federal, state, and local governments?
We don't really have a centralized system that would track that because they don't go through Octo. Octo may facilitate requests to provide data. We facilitate, FOIA, certain aspects of FOIA when it comes to email or phone systems and stuff like that. But if we're not party to the request, it's not necessarily something that we're tracking.
Okay. Are you aware of any areas where exemptions should be established for agencies or third parties handling data?
As far as exemptions, not necessarily. We've got various, we do have some things around compliance with district laws, right? What are those agencies allowed to collect or transfer to be compliant with the law? Maybe that's something like tax collection or benefits administration. Those are just required functions for those district laws. We have compliance with obviously government inquiries, so things like subpoenas, court orders, federal criminal investigations. When services are requested by individuals, they need to collect information about that individual so we can adequately respond to them, whether it's permits, benefits, things like getting your license. And then obviously assisting other agencies with data transfer just to fulfill its obligations. So things like if the police department needed to share with courts or health department needed to share with schools, those kinds of things.
And if a district resident or user of district government services wanted to obtain information about how their data is collected, used, or transferred, what would they need to do, or who would they need to reach out to?
Well, for now, that can be fulfilled with a FOIA request,
Okay.
but it would have to go down to every individual agency, and it would tend to be at this point an overly burdensome request if it was broadly provide me with all information you have about me.
Mm-hmm. Okay. And would that vary by agency, or that's the centralized FOIA?
The FOIA process itself is centralized. The
Yeah.
FOIA tooling is centralized. It's within Octo. Yeah,
Okay.
as you're aware. Yeah. That before.
All right. So lines 176 through 188 of the bill allows individuals to request their data and related information from agencies. Is a 60-day timeline sufficient for agencies in coordination with Octo to respond?
I don't believe so. Again, it can be overly burdensome. There's a lot of systems and a lot of data, and how an agency identifies an individual can be different in each application or each data set that they have. So, we'd have to be able to get through that. At this point, I don't believe 60 days is reasonable.
And what do you think is?
It's tough without going through the actual kind of stakeholder engagement on this. It's hard to really say. And I do, of course, I'm concerned about an initial surge of requests if the bill were to go through, and this process was part of that. Longer term, it may be possible in a year or two that it's 60 days, may be possible that it's 30 days. It may be possible that it gets down to something that can be fulfilled within minutes with future technology, with the way that it goes. But at this point, I'm not comfortable throwing a timeline on it.
Okay. And do you anticipate staffing workload or capacity challenges with fulfilling those data requests?
Definitely in the beginning, I do think we'll be overly burdened with requests initially for people to pull data. Yes. And it may, large scale agencies that collect a lot of data, it'll be burdensome just because of the volume and the number of systems we'll have to go across. And of course, at small scale agencies with fewer systems, they may not have the staff to dedicate to perform the research and pull the data together.
Do you have any other concerns or recommended changes related to this provision?
That provision, I think, again, it just creates a significant capacity and capability burden within agencies. So yeah, there'll be, organizational change management, getting them to understand how they fulfill it is different for each agency. Again, it's going to depend upon each individual application or data set that they have. And again, generally, residents have unique identification in a lot of the systems themselves that we run, not just within the agencies, but the systems within an agency.
Sorry, we just alerted that there was a data breach at the Housing Authority.
Housing Authority is not under our specific authority.
Understood.
But yes, I am aware of this.
If you need to take a break or anything, let me know.
I'm okay for now. Our Chief Information Security Officer is not in the hearing, so we're okay.
Perfect. Okay. Are residents currently able to opt out of data collection or transfers?
We do not have an opt-out process at this time.
And how feasible would it be to implement the proposed opt-out provision?
We'd have to understand what they can't actually opt out of. That's one of the main things, right? You can opt out, but we still have to pick up your trash. We still have to, you still have to call 911. You still need the police. You still need schools. So we'd have to understand what is capable of being opting out of. So it could be, opting out of, whatever tracking on our websites, which is used for analytical purposes. Well, that's anonymous and aggregated anyway, so we don't know necessarily that it was Matt Sokol that visited the page. Again, we'd have to work with agencies to understand that impact broadly and the capability of doing it, and then the exceptions that we would have to build in for that process.
Are there any practical barriers to allowing individuals to withdraw consent and require agencies to stop using their data within 45 days?
Yeah, I think again, it gets down to that mission specific. We'd have to understand that within that agency level. Yeah.
Under what circumstances is data required by law to be retained?
It's going to be under those individual laws, the health health insurance portability, FERPA, et cetera. As you get through those, each have their own individual retentions, and then each agency also sets its own retention policy itself.
Okay. What factors determine the length of time data is retained by an agency?
It depends on their capabilities to retain that data. It depends on their need to retain that data.
They may also have specific audit requirements that need to be fulfilled. So if they have to retain it for 7 years to meet those audit requirements, they'll ask us to retain it for them on storage for 7 years.
Which agencies would be under audit requirements?
I mean, there's various standard audits around HR and health, and I don't have all the specifics to those, but they have some
Things
different
like
retention.
that.
Yeah.
Different retention
I mean,
policies.
CFSA has its reasons why they have to keep retained data for certain amounts of time. OTR, same thing. Yeah.
Okay.
Yep.
Are there any established limits on how long a third party is allowed to retain transferred data?
Established limits, no. That likely would be party to the contract
The
itself.
contract.
Yep.
What district offices or individual is responsible for ensuring that data is not retained by agencies or third parties longer than it's supposed to be?
I don't believe there are, I think that comes down to, it comes down to contract practices. It comes down to, understanding, communication, collaboration amongst the general counsel and the contract administrators.
So is retaining data is not necessarily only a passive activity because of the work that you have to put into to manage that data. Is that right?
That's correct. Yes.
Okay.
I mean,
we don't accidentally retain data longer than we should.
We don't. We actually at Octo, we push to have tighter retention policies. We have very loose retention policies now, which drive up our operational costs. The benefits of it is it's more data that's available to our security appliances to help make decisions in that. But yeah, ultimately it's mission driven, very pragmatic driven within the agencies as well.
And is it really up to you to be the one pushing on those retention policies?
I mean, we certainly have a voice in it. Whenever we talk through our budgetary asks related to infrastructure, it's always a topic. When we talk about, I was party to conversations when we moved from on-premise email to M365 email. Like that was, again, that was a part of that conversation because we have to make sure that that information is still discoverable, still foilable. If we're holding on to it, it needs to be in all of our audit tooling, it needs to be in our security tooling. We have to make sure that we're keeping that data safe and secure and that we're finding some value out of it, again, usually within that security space.
There's been some recent news about an independent developer putting together their own 3-in-1 app because OUC's has been out of commission. And OUC reportedly had concerns about data privacy, and it looks like the independent app has been taken down. Does Octo publish API security standards or a developer policy that a third party could actually comply with?
We do publish standards on this. We do have, at least internally, API capability tools that we provide to agencies. Is there anything you want to add on that, Matt?
Yeah, so we do have those for some of the tools, and I think it was mentioned earlier, we have certain aspects of it, certain specific types of calls you can't make through our APIs or rate limiting, which is, again, we talked about that earlier, the number of the amount of data or requests you are sending through to us or a specific platform. And then obviously there are other platforms that we subscribe to or are customers on that also maintain their own terms and conditions for those kinds of developer platforms.
Yeah, it's important to note, we have no security oversight of third-party applications that are unauthorized. So we don't know what information is being collected. In this case, we do. They're being pretty open about it, but we don't know if there's a bad actor that can get in the middle of this application. We can't protect that application from bad actors. We can't protect that application from creating a denial of service attack against our API layer. We welcome civic development. We certainly do with our open data. We think it's important that civic developers take the time to create dashboards to hold us accountable, to create transparency in the government. But we do not want third parties that are not authorized to represent themselves as a government service, because we can't guarantee that their requests are getting to the government like we can where we have our oversight and control.
Open 311 is an established open standard that cities have used specifically to let third parties build 311 clients securely, and DC was previously involved in this effort. Has Okta evaluated an official, authenticated, documented public API with developer terms of use?
We would have to make sure that we're putting together something that remains flexible. We would have to make sure that we're putting together something that still delivers what our agency partners need. It is bigger than just 311. The service fulfillment agencies have very specific requirements on what they want to see in their work orders that they can complete the tasks. So, we also operate differently. We're not Baltimore City, Baltimore County. It may work well for them, but we provide more government services than they do. And Open 311 really doesn't have considerations for someone that operates as broadly as the district does.
Okay. Our 311 system is built on Salesforce, right?
It is. It's a proprietary solution from Accenture, from a acquisition they got from a company called Encapsulate. It's a mix of Amazon Web Services and Salesforce services.
If I recall correctly, making tweaks to it is very expensive.
Making tweaks to it. There's different ways to define that. They have contractual obligations under the current contract to perform maintenance and make upgrades at our request. But the upgrades themselves to add new features, we are part of a kind of a common operating group amongst other cities and counties. So making a feature request to the base platform isn't necessarily a DISH requirement. It has to be a requirement of the majority of their customers in order to get it done. But maintaining the application, keeping it bug-free and operational is within the contract itself today.
So we're different than Baltimore City and Baltimore County, but we're held to the same standard as other cities when using this app, and we can't modify it?
We can modify it to a degree, but we can't get 100% customization out of it because of the nature of the application. They created a commodity that they are selling to multiple jurisdictions.
And is it broken in every city they're selling it to right now?
Some of the issues that we have had, other cities and counties have had those issues as well. My
When's it
understanding
gonna
is that
be?
it's not broken for those at this time.
When's it going to be up and running again?
Ours is up and running today. We were
As
able
of
to-
today?
Yes.
Because of today's hearing?
Well, not necessarily because of today's hearing, but no, we worked very hard to get them to fix the issues that folks were seeing. We were able to get an update out that fixed the issues that people were seeing. Unfortunately, there was a bug that wasn't caught where if you weren't signed in, you couldn't have an email address that started with a number. That was a bug. We got them to fix that. That is now up there and live. Unfortunately, we had an outage of our enterprise geospatial layer that impacted the mapping capabilities of that app. That was last week, but that's fixed now. So right now that application is, to the best of my knowledge, operating at 100%.
Well, we're going to try it now, so.
It's fine.
All right. So what are the duties commonly tied to a chief privacy officer?
Yeah. So there's a couple of different things that they would be able to do. They would, again, they'd be performing some level of audit. They'd be performing some level of policy development. They'd be doing compliance reviews. They'd be doing impact assessments. They'd be, again, documenting and auditing the services that we're offering, documenting and auditing vendors that are involved in data transfer, documenting and auditing any third-party transfers of data. They would be involved in our breach response, our incident response. I prefer incident over breach. Let's be clear. Not every data incident is a breach.
Okay.
They would be involved in complaint investigations. If we were to go down that path, they would be involved in training and education. I think that's a very important aspect about this, is that we have to get all of our government employees to understand that they have a responsibility in this as well, just like we do with cybersecurity today. We have mandatory cybersecurity training. We may end up having to develop mandatory data privacy training as well across the city. They would provide advice to myself, to the city administrator, and to the mayor on data policy in addition to our chief data officer here. They would also work on requirements and policies that would be contractually mandatory as well. So they would be involved in that. Yeah, that's what's top of mind for us. I probably didn't hit everything they would do. What I'd say is we are learning more about what a chief privacy officer would look like at Octo. We're working with, our trade organization with NASIO to talk with other chief privacy officers, to talk with other chief data officers, to talk with other chief information security officers on how their roles fit in this as well.
And how would the establishment of this role address current gaps in government data privacy?
It would create a single focused point of contact for it. It would be a dedicated person that was providing privacy advice, rather than just individuals with an agency doing this as other duties as assigned. So we would have an expert that would be similar to my role, similar to Matt's role or our CISO's role. They'd be in a community of practice regionally. They'd also be nationally in a community of practice as well. So yeah, we'd fill in quite a few gaps as we learn more about it.
And how would the CPO coordinate with agencies and the CTO?
Sure. So, we're in the government operations cluster. We have a lot of coordination that we do already today. So we meet regularly, for example, with CIOs and IT leads to talk over our initiatives, to talk through our practices. I'm all about open communication. I'm all about interaction with our stakeholders. So we would work with government operations to work with city leadership, to work with agency directors, to work with their IT staff, to work with their legal staff, to get them to understand, the direction that we're going. We would leverage our experience with those things, with planning, with implementation of the supporting systems, with documenting processes, procedures. We would work with the agencies on that, and then we'd leverage our reporting structure through the government operations cluster and the city administrator to ensure that agencies are remaining compliant. So, similar to, how we handle cybersecurity today, it would be, a regularly occurring meeting to go over the concerns that we have, to go over bad practices that we found, or to, go over incidents that we're currently investigating and complaints.
Are there additional duties you'd recommend adding to the role other than what you said, other duties as assigned? But
yeah, I think it's kind of important, maybe a public advocacy role. I do my best right now to act as a public advocate when it comes to cybersecurity. Every year, leading up to the winter holidays, I try to get some radio time to go talk about what our role is, what our role as individuals are to protect our own data. It'd be great if a chief privacy officer could also be involved in that kind of public advocacy.
Do you think it'd be beneficial to designate data privacy counterparts within agencies to coordinate with the CPO?
I think in larger agencies,
okay.
Yes. Agencies that have very specific federal practices, maybe very specific regulatory practices that they have to adhere to. I don't think it's appropriate for every agency. I think, there'll be some agencies where this is a 0.01% job time job. But there will be agencies like, the Department of Health or the Department of Human Services or, CFSA or even, DMV where it's could be near a full-time role. With the amount of data that they are protecting every day.
And does the proposed submission deadline of August for the annual report align with data collection and preparation schedules?
I think it would be better to do it at the end of the calendar year as opposed to closer to the end of the fiscal year. I just think it gives us a little more time to get through things like things like it ensures that we get through data cataloging and classification in the first quarter of the year. The second quarter of the year is responsible use of data training. The next quarter of the year is cybersecurity training, and then I think it really we kind of meld this all together into a report at the end of where we stand on all of that.
Okay. And does the district have anything similar to a data privacy bill of rights?
No, I don't think we do. I think there's bits and pieces that would be part of a privacy bill of rights that would be in our policies. But there's nothing that is documented specifically as a data privacy bill of rights at this time. And again, until we talk to those agencies to get their kind of feedback on how this will impact them, it's kind of hard to put something like that together. Yeah, to understand what that challenge would look like.
And does Octo or any other DC agency currently perform privacy impact assessment?
We do not know.
And-
I'm not aware of any agency doing it at this time. But yeah, that just may be that we're not involved in it.
And what benefits do they provide?
It's going to provide guidance to ensure privacy is it's embedded in the design and the planning of our projects and initiatives. I think that's very important. Again, getting everyone to understand their role. They can help to document the risks that may not come up necessarily during the existing gateways we have in our IT projects. So it's a little more oversight. So there's a benefit with that. They can help to create transparency and accountability for decisions regarding the use of our data across the district. They can increase compliance just due to that higher degree of documentation, that audit capability, the guidelines that they're putting in place, those documented practices. And then, most importantly, they can help us to increase resident trust in the digital services that we offer, because I think that's very important. If people are concerned about providing us with data, they won't necessarily apply for government service. So we want to make sure that we are creating resident trust. We want them to know that we're handling their data appropriately, and we want them to know that they are still getting the government services that they ask for. We just need your name every now and then. Sorry.
The bill outlines several enforcement mechanisms available to Octo to ensure agency compliance, including issuing written findings, recommendations, and directives to an agency. Can you talk a bit about how these provisions align or potentially conflict with Octo's existing power?
I don't think they really do. So we don't have a whole lot of enforcement authority today. So nothing really gets in the way of that. Our compliance just tends to be with making sure that they followed our guidance, we'll say, in a post-incident report or an analysis of why there was, say, an outage. We want to make sure that we have the capability of protecting the residents' data. So an enforcement provision, could allow us to have a series of reasons to take an application offline if it's got violations, or take a data set offline. Yeah. But no, we don't have anything existing today that would get in the way of
that. How would Octo coordinate with OAG or the appropriate enforcement agency to ensure compliance by agencies?
We'd have to work through it like a standard operating procedure on it, since it doesn't exist today. I mean, we can look at how we do coordination today on other things, not necessarily with OAG, but coordination like with the Office of Risk Management on our incident response, coordination with how we handle. I think incident response is a good starting point for that. So we need to document and implement those standard operating procedures to support the intake and the referral of noncompliance. Where enforcement is necessarily, or where that coordination with OAG is necessarily. We need to set up systems and processes for information sharing, for logging everything that's coming in, for decision support and appeals as part of that process. We need to make sure that we have a process that supports continuous improvement, because I always say this, we don't get things right the first time, but we want to get it right so that we can get better over time. So I think, at least initially, you're probably looking at monthly coordination with an agency if it was OAG, and then down the line, probably quarterly catch-ups, and then as needed incident response meetings would be set up. And regular case reviews, we'd have to see what that caseload looks like for enforcement.
Okay, thank you.
Mhm.
I think you said earlier you don't currently have any enforcement authority. Is that right?
Yeah, we don't. We can set contractual requirements. We can recommend, I should say, contractual requirements. We can set standards for agencies and vendors. The enforcement authority we have is very limited, I think is the way to put it. Like, we can recommend Today, we can recommend an agency cancel a contract, but we can't necessarily, we can't cancel the contract ourselves. And unless there's something specific in the PPRA, OCP is really going to be dependent on us to have something very well documented reason to separate with a vendor. We can restrict individuals from accessing the network and, from accessing certain systems for non-compliance. And again, that comes down to that, did they complete some of that mandatory training or are they, acting like bad actors? And then, it just comes down to if it aligns with our cybersecurity practices, we have a little more authority on enforcement, but there's nothing that actually codifies us as being capable of doing this from a data privacy standpoint.
And would Octo be able to effectively enforce data privacy practices using its existing tools?
Again, no, we don't have any tools that are built for this. So we'd have to evaluate what that would have to look like. We certainly have things like, understanding of what's in the catalog, what's in that data catalog. So we can, we can understand what was in any data that was non-compliant, but no, that enforcement authority, unless we can find a way of tying it into cybersecurity, no.
Oh, interesting. Okay, so what additional authority, resources, or funding would you need?
It would be that privacy enforcement authority, audit authority to ensure compliance, investigative authority, again, to handle complaints, potentially debarment authority, but I think we can accomplish that through OCP.
Okay.
If there was a, significant violation by a third party doing business with us. And then I think it would be extremely beneficial if it was enforced that all data had to be cataloged and classified year over year.
Okay.
Today, it is not enforced. So yeah. And then, funding is hard to figure out right now. We'd be hitting into a labor market for like a, chief privacy officer. We've never selected one before. We'd have to, we have 700,000 residents. We have a lot of data. We'd have to see what that would look like. That would be a big part of that budget allocation, researching the systems that would support this. We have a good idea of what audit systems would look like and what they cost, but we'd have to see if they're compliant, if they meet the needs. So I can look at what OIG has, for example, that helps manage their audits today and come up with some budgetary numbers, but whether or not that actually meets the needs of auditing from a data privacy standpoint, we're not fully aware of that yet. It'd be great to get, it'd also be great to figure out, get clarity, I guess, on that enforcement, which agency will handle enforcement.
Yes.
Yeah.
We will need that.
Yes.
Okay. Well, thank you. Those are all the questions that I have for you today.
Well, thank you.
All right. And this concludes today's public hearing. For those who plan on submitting written testimony for the record, please do so by going to the council hearing management system. The record will close on Monday, July 13th at 5:30 p.m. The time is 12:19 p.m. and this hearing is adjourned.